Hello, everybody, and good day to the policy series of the European Banking Institute. Today's policy series is about the new European AML authority, the AMLA, and we have a simple name for that. It's an introduction to this new authority, which doesn't exist yet, which is about to be established and about to take up its work next year. The final decisions in relation to this authority have been taken, which is obviously key. Where is it sitting? It's going to be based here in Frankfurt, but the overall package in relation to the AML package of the European Commission was, I think, approved end of last year. And it entails the establishment of this new authority, but also some material reorganizations of the AML supervision here within the Eurozone. And I'm very happy that we have various speakers for this conference here today. First of all, Olena Loboiko. She is policy officer at the European Commission. In the same sense, I need to excuse Raluca Pruna, who was supposed to be here but had to decline today for a personal reason. And I'm very glad that Olena is able to step in. So thanks very much for coming, Olena. And Olena is policy officer, as I said, at the European Commission, is currently working in the financial crime unit of DG FISMA with over 12 years of experience and expertise in European regulatory and policy framework in the financial sector. Over the last 4 years, Olena has been involved in all of the Commission's initiatives in the area of anti-money laundering and countering the financing of terrorism related to the financial sector, including the recently adopted AML and CFT legislative package, where Olena was responsible for the regulation establishing the EU authority for anti-money laundering and countering the financing of terrorism. So that's the long version of AMLA. That's the way I will call it in the course of this series today. Otherwise, we'll need an extra time. Previously, she has worked in the banking unit of DG FISMA in the area of prudential regulation for banks. And before joining the European Commission in 2017, Mrs. Loboiko has worked at the Netherlands Bank, so the Dutch Central Bank, in the area of prudential supervisory policy for over 5 years. She received her LLM in European Union law from Erasmus University of Rotterdam and an executive MBA from Business School at the City University of London. So welcome, Olena, and thanks for being available in such short notice. Then we have two co-discussants. First of all, I would like to welcome also Andrea Minto. He's member of the ARG of the European Banking Institute and at the Jean Monnet Professor of Law and Regulation of Financial Markets and of Counsel at Annunziata&Conso. So welcome also to you, Andrea. And last but not least, I would like to welcome also Roger Kaiser. He's from the European Banking Federation, which he joined in the year 1999, where he's currently head of tax and compliance and in charge of AML and CFT, financial sanctions and tax questions. He's a member of the steering group of the Europol Financial Intelligence Public-Private Partnership. He's also a member of the tax committee of the business at the OECD and co-founder of Revue Fiscalité de Placement in Belgium. Before joining the EBF, he was advisor at the Belgian Finance Ministry in the fields of corporate taxation, withholding taxes, and banks tax audits. He's a certified AML specialist and certified tax advisor. So, Roger, also welcome to you, and thanks for joining this event. So, as I said, the AML is about to be established. I think the last big European authority being established was the SRB, which started its work in 2015. The SSM started in 2014 its work. So now, again, a new authority, which is, I think, very exciting. It goes back, I guess, to the time where one bank in the Eurozone failed because of allegations of AML. And that led into the discussion to establish a new European authority to better coordinate anti-money laundering. And this authority or this negotiation process is finished now. Now it's about to establish this new authority. And just very briefly, it will have actually also direct supervisory powers for certain member institutions. And it will also coordinate the oversight of national AML and CFT supervision. So in that sense, it's got a very big mandate, I would say. I think also quite a lot of people will be hired now in the coming months. And I'm very happy now that Olena, who has been very much involved in the process for writing this regulation, for basically setting the groundwork for the establishment of this regulation, that she's with us today. And I would hand over to you, Olena, for your opening presentation. Thanks very much.
Thank you very much, Thomas. I hope everybody can hear me well, and I am going to share my slides in just a second. And if you should see my slides in good order, I think I can start.
Yes, we see them.
I'd wish to say that I'm stepping into very big shoes today of Raluca, and I hope I'll do justice to her intention to convey to you the message of what AMLA is meant to be, how we have conceived it in the Commission, what was the vision of the co-legislators, and what actually will make it a success in our view. And then we can discuss, because we may have different visions of this road to success of AMLA. So just as a brief introduction, AMLA is obviously a part of our big reform in the space of preventative framework in AML area. It is the institutional part of it, but we also have a big reform of substantive law, represented by the new iteration of the directive, the AML regulation, and the recast of the transfer of funds regulation. But in the interest of time, let's jump into AMLA and what it is in a nutshell. In fact, it has been established already. It legally exists since 26th of June, so just some days ago, really. And that was 7 days as of publication of the rest of our legislative package in the official journal of the EU. So it legally exists. It will at some point substitute in the area of AML the EBA, which has quite a limited mandate right now. And it will be so much more than the EBA. So what is AMLA meant to be? First of all, it will be a regulator, because the big part of our reform and a big rationale of our reform was the need to establish a level playing field and a true harmonized single rule book to be applicable to the industry, to be applicable to our gatekeepers. And obviously the AML regulation and the directive are a bit part of this rule book. It's the skeleton, really. However, a lot of the details still need to be worked out and put in place, what we call in a form of the level 2 regulation. That's what AMLA will be in charge of. You've already mentioned, Thomas, that indeed AMLA will also be a supervisor, and in some cases really a direct supervisor for certain obliged entities in the financial sector, which will be selected periodically. And we saw the need for that, considering the current fragmented approaches to supervision and very national-based supervision, which we think would benefit, in some cases, for some entities, from a single authority with a universal EU jurisdiction, being in charge of some entities, and also seeing how the supervision is done at local level and making sure that it complies with the same standards. For the rest of the financial sector and the entirety of the non-financial sector, where we have probably hundreds of thousands of gatekeepers, right? AMLA will be a supervisor of supervisors. I actually put the term watchdog, which I personally do not like, but this is how everybody is talking about the concept of supervisor of supervisors. Whereas what we are trying to put in place is actually a center of the system, trying to connect these national public authorities, national supervisors, into an integrated system, reflecting the integration of the single market as well. And last but not least, and that's the second important area of the institutional part of the reform, is making sure that AMLA is also connecting financial intelligence units, that it actually becomes a center of financial intelligence in the EU. while we are not substituting national financial intelligence units, we think there's a lot of space for making their work both more effective and more efficient, and in some cases to even producing the financial intelligence in real time jointly by them, as opposed to just bouncing the information about the suspicions that they receive. So that's a very, very big task and a very demanding task as well for this new agency, which, as we all know now, will be located in Frankfurt. So it's true that in a steady state, we expect AMLA to reach over 400 staff members. And then the question would be, do you think it's a little or a lot? And is it enough considering the tasks that we're putting, the mission really that we are entrusting this agency with? And my answer would be, and that's probably the most important message that I want to convey today, is that it would depend, and it really, really hinges on a few things that depend on not just on AMLA itself, but also on this entire community of the national supervisors and national financial intelligence unit where AMLA is stepping into. The idea is that, again, it becomes a center of a system. It will be a coordinator, it will be a regulator, but it will do those things together with national authorities. Currently, what we have in the EU is everybody is responsible for their own turf, both in terms of supervision, but also to an extent in terms of working for production of financial intelligence, getting it and translating it into leads for the law enforcement, right? And that is not efficient because that is not how single market works, and that is not how criminals work. There are no borders within the EU. So what we are trying to get to is establishment of common sense of responsibility, really, for the successes, but also for the failures. So there needs to be absolute trust among all these authorities that are going to be part of AMLA governance structure, that they have to help each other, that they are working on something together, and there's no limits, and there are no turfs, and there are no individual successes or failures, and there are no separate supervisory methodology. That is the most important mission, to build this trust. And all the individual tasks would really, really depend, and the success of them would really, really depend on how invested all individual authorities at national levels are to making them a success at EU level at AMLA, starting from the most popular topic of direct supervision. Because the supervisors that AMLA will rely on would be not only its own staff members, and actually predominantly not its staff members, but the staff members at national level, just like in the SSM. So we took a model that we thought worked quite well, this cooperative model, joint supervisory teams, but decisions taking in the center, and we extrapolated it to the AML world, and that's what we hope will work. If that trust and that cooperation is not built, if we still have a fragmented system where AMLA takes a step back and is just a watchdog in case something fails, it's not going to work, not with 400 people, not with 4,000 people. So specifically, what could we do as the Commission and as the co-legislators, really, to make sure that we have a good groundwork to make it happen, right? We had to make sure that the legislative framework for it is appropriate. And all the concepts that we are putting and we are discussing today, like a common supervisory system, have a legal underpinning in two distinct areas, the supervision and the coordination of financial intelligence units. So in the supervision bit, in this idea of the common supervisory system, we have two somewhat different approaches to the financial and non-financial sector. In the financial sector, where we already have quite a bit more, let's say, supranational powers and integration, we are giving AMLA indeed the task of direct supervision for a very limited part, unlike the SSM, for example, and a lot of powers of oversight for the rest of the financial sector. In the non-financial sector, we're only sort of putting our toe in the water for the first time ever. And we were trying to have EBA's powers in the financial sector as a model, but we went a bit beyond that. So it's a bit more of an oversight. It's a bit not as directly in touch with the sector itself, just with the sectorial authorities, but it is a very, very big step forward in terms of what we're doing at EU level in the non-financial sector. So I'm not gonna go into details on how the direct supervision selection is gonna look, but I'm happy to answer any questions that you may have. Again, the idea is that in some cases, it would be more efficient to have a supervision at supranational level. And those would be the cases where there are entities that are operating in a significant number of member states. And at the same time, they require a lot of supervisory attention because their business model is inherently risky. And also their controls are not necessarily mitigating a bulk of that risk. So they have a high residual risk. They operate in a lot of member states. A priori, they require a lot of supervisory attention. AMLA would be much more logical and authority for them. Since these risk profiles could be shifting, we're talking about periodic selection of every 3 years, and we're also making sure that the entire single market is covered. And we have this number that co-legislators agreed on, that it would be limited to 40 entities in the financial sector for the very first round. But then, if all goes well, as of the second selection, there may not be necessarily a limitation on the number of entities to be supervised directly. For the rest of the financial sector, in order to give this concept of the single supervisory system substance, and really legal substance and practical substance, we have given certain powers to AMLA to look at how the common methodologies are implemented, so assess the state of supervisory convergence, to help in the AML colleges, to be able to troubleshoot, to have firefighting powers in case there is an entity or entities at national level whose, for example, risk has been underestimated or materialized really unexpectedly, and the national authorities do not have the capacity or the time to address it quickly at national level, so that AMLA could be taken over. Again, reinforcing this idea that there are no problems that are purely national, there are no failures that are purely national. Any problem is a problem of the entire system. In the non-financial sector, like I said, a bit similarly, but somewhat a lighter touch to an extent at the beginning, because again, the role in colleges, the peer reviews, a power to mediate disagreements, but without a binding effect. In both sectors, we also gave what we call horizontal common tools, such as ability to conduct thematic supervision at EU level or coordinated, have the AML CFT database with all the key supervisory information, be able to establish common reporting and interactive platforms with the industry for supervision at both national and supranational level. Last but not least, and I'm going to stop in a bit, for the FIUs, how do we think we're going to make a tectonic shift really in this space? So first of all, AMLA will be equipped to support them technically. It will be hosting the FIU.net platform, the platform for secure information exchange. It will also be able to put in place common policy and regulatory instruments, such as common templates for the reporting of suspicions, in order to foster this information exchange. But most importantly, it would be able to host, coordinate, and participate in joint analysis of cross-border suspicions and suspicious transactions or activities. So chase the cross-border crime in real time at EU level by uniting the FIUs, as opposed to letting them just bounce around the information they have and trying to put the pieces of the puzzle together. So that's our biggest idea here. And to reinforce it, we're also requiring each national FIU to send their own delegate to AMLA on a rotating basis. And now the last slide is how is it going to look in terms of governance? So in terms of how this authority really would be structured. So we will have the national representation of both the supervisors and the FIUs in the so-called general board, which you see at the bottom of the slide in two alternative compositions, which means that essentially national authorities and national FIUs would be in charge of the policy development and agreeing on common supervisory methodologies. But the direct supervisory decisions we thought would be more efficient to entrust being taken by a smaller body of permanent independent members, chair and 5 more. And also the smaller body is going to be in charge of running the authority administratively and taking all the decisions, including on the budget and the staffing and the structure and such. The chairperson, and that's my last words, is going to be the first top manager to be hired. We have published the notice already for the call of interest, which expires, I think, on 8th of July. And we hope to have the chair appointed towards the end of this year, and then the rest of the executive board early next year as well. So those are the first sort of administrating steps in terms of the governance authority that we're putting in place. And I stop here in the interest of time. And like I said, later on, I'm very happy to answer your questions.
Thank you very much, Olena, for this very good presentation. We will go into the questions after. I would give the chance now to Roger and Andrea for their view on this new authority and on the whole substantive part. Roger, maybe I can start with you and hand over to you. Thanks very much.
Yeah, thank you, Thomas. Yeah, I think Olena has already provided a very good and comprehensive overview. I will try to maybe put my interventions I mean, into the context of why we are there today, why AMLA is now set up, and what are the objectives, and maybe draw attention on some points of interest, particularly from the perspective of the European banking sector that I'm representing. So allow me to take a step back to 2016, when the Panama Papers was everywhere in the media and made the headlines. This event was the start of a series of AML scandals, which I think have contributed to raising awareness about money laundering risks and the threats they represent for society as a whole, and for financial institutions as gatekeepers in particular, also for their integrity and stability. And it's in the wave of these scandals that consensus grew about the inefficiencies of the EU AML framework, its functioning, its supervision. And so I would like, as an introduction to the discussion today, to raise what I find a quite relevant question, and which is whether the AML package and the establishment of AMLA have the potential to address these inefficiencies. I would classify them in 4 categories of inefficiencies. First, and I think it's very much what Olena has already mentioned, by the way. First, the regulatory and supervisory fragmentation, which complicated the development of an EU approach to AML. So there was a critical need for consistency at the EU level and for a reduction of the national divergences. And that's now precisely what AMLA will address by establishing a single integrated system of AML supervision across the EU based on common supervisory methodologies and the convergence of high supervisory standards. The establishment of AMLA is also a unique opportunity to revisit the regulatory technical standards, the RTS, particularly in a number of areas, but very much with a focus on customer due diligence. And I would like to briefly emphasize that there are three principles that should be taken into respected when developing the RTS. That's first to conduct prior impact assessments. Second, to respect principle-based approach under the motto "less is more," I would say. And finally, what is not clearly provided in the regulation, but very much advisable, it is to conduct ex post impact assessment. The second category of inefficiencies that were identified over the last years and prior to the presentation of the AML package is the fact that over the years the AML directives have developed into a very legalistic approach for AML, focusing very much on the compliance of obliged entities rather than on the effectiveness of the fight against financial crime, and so departing from the FATF principle of a risk-based approach. So it's very much welcome that today obliged entities will be requested to focus on risks, and that supervisors will focus, and particularly the AMLA will focus on the riskiest obliged entities via the direct supervision. Now, in relation to direct supervision, there are a number of pending open questions that we will need to clarify, particularly the question of how the risk assessment prior to the selection will be conducted for groups, because it will be a huge task for AMLA, which will be in the first year of operations. The third category of inefficiencies that I would like to mention is the lack of cooperation and information sharing. Information sharing and cooperation, which are absolutely key if we want to develop an intelligence-led approach for AML. And during years, all actors of the AML ecosystem, the AML community, have worked in silos. So again, something which is very welcome in the package, and particularly in relation to AMLA, is that first, one of the key functions of AMLA will consist in support and coordination mechanism for FIUs, and other novelty, which is very much welcomed, is the possibility for AMLA to enter into public-private partnerships, and so to cooperate with obliged entities. That's really a big novelty, because you have a supervisor who will work with the obliged entities, so with a totally different approach from compared to the past, and that's where we will need to build trust. So it's not only limited. The trust will not be limited to the authorities, but also we have to build trust between the authorities and the obliged entities. Now, moving to the last category of inefficiencies that I wanted to mention, there was a suboptimal use of innovation. Innovation is very important. We should, as obliged entities, we should exploit more advanced artificial intelligence and machine learning tools, particularly in the detection of criminal activities and suspicious patterns. And I think this should be recognized and taken into consideration by the supervisors. One big challenge for the AMLA will be to balance its central role with the national competent authorities. So I wanted to mention that. We want to avoid, notably, the risk of forum shopping, the risk of any duplications, overlaps. I think they are safeguards, but we will need to be very careful. So in a nutshell, I think we very much welcome the setting up of AMLA. AMLA is very promising. It has identified the right priorities, which are prevention to risk assessment, the risk-based approach, extremely important, the need for consistency, harmonization, a level playing field, and the need for cooperation and exchange of information with all the actors of the AML community. Now, the principles are there, the commitments are there. We now need to realize that there are a number of challenges, but I'm sure that we will manage that. And I'm very happy during the Q&A to address some of them. Thank you.
Thanks very much, Roger, for these remarks. There are already a lot of questions which pop up when I listen to these two opening speeches, but I would like to give the opportunity to, first of all, to Andrea, who has been looking into this from an academic perspective a lot in the past. So, Andrea, over to you for your remarks.
Thank you, Thomas. I'm really happy to be here today because I learned a lot already. So I will just share a short presentation to build on what has been said already on the topic. What I would like, to stress out is the importance, the relevance of the AML CFT supervisory system. Because indeed, everybody is talking about AMLA, and of course the focus is on the new agency, the new authority, which is indeed like, a turning point in history. But I believe, and this has been said already by the speakers before me, probably the most relevant reaction by EU legislators is the introduction of this new framework, where we have, of course, at the epicenter, the AMLA, but it's actually a setting where we do have the cooperation of this new European agency with the national competent authorities. And in this respect, I would like to say something more about the framework. So indeed, history is made, and the package is bringing about a substantive and institutional reform, and in particular today we are focusing on the institutional impact of the package with an analysis of the anti-money laundering authority. This agency is indeed entrusted with fully fledged tasks and powers, which are not limited to the supervisory tasks. So not in particular, I'm referring to the direct supervision of Article 12 of the AMLA regulation, but it, as Ms. Loboiko said, it's a regulatory body as well, and that's quite important, I believe. So if we see indeed the different areas where the AMLA is competent, we do realize that in fact there's a wide range of activities that are carried out by this authority. I'm not entering into all of them because we have been discussing them, but I think it's important, you know, to keep them in mind also because we already witnessed at the European Union level the activity of a European authority involved in anti-money laundering. And of course, I'm referring to the job that has been performed by the European Banking Authority. So since 2019, with the revision of the establishing regulation of the EBA, this authority, this European agency, is indeed carrying out, you know, tasks and powers connected with anti-money laundering. In particular, I'm thinking about Article 9A, B, and C. And of course, I mean, the EBA has done a wonderful job, but, you know, the mandate of the EBA is limited. And first of all, because of course it can be concerned with the financial sector only, but second, because it's not, technically speaking, a supervisor, but it's more involved in the regulatory part. And, you know, in promoting, to some extent, the convergence of the supervisory practices. So, in light of the experience that we gained with the EBA authority, and most importantly, because of the scandals that came about, and because of the supervisory fragmentation that those scandals showed, we needed indeed to, you know, put forward an overhaul of the institutional setup. And in this perspective, the introduction of the AMLA, and more in particular, this integrated AML CFT supervisory system, seems to be the right answer to the major challenges in this respect. Now, as I said, the AMLA is an authority, is a body, one of its kind. I mean, it's very peculiar, and it is combining both regulatory and supervisory powers, and it's quite interesting. You know, I'm a little bit of a nerd in this respect. I'm just, you know, looking at the different regulations. It's funny to see that the AMLA regulation is more or less, you know, the number of articles is the sum of the articles that we find in the SSMR and the EBA regulation. Of course, it's not a merge of the two regulations. We are talking about, you know, specific, but it shows how articulated, you know, this authority is, and how it's indeed somehow, you know, building on what we have learned from the SSMR and from the SSM experience and from the EBA regulation. So, looking more in details about into this single supervisory system, which is in chapter 2, title 2 of the regulation, what I think it's very important is Article 7, 8, and 9 of this regulation. Article 7 is somehow, you know, proposing what we can find in Article 6 of the SSMR, so the principle of cooperation between the different authorities, and the fact that the European authority is at the epicenter and it is coordinating the different jobs. So it is responsible for the good functioning of this system, of this framework. But more important than that, I would say, is Article 8, that is really the core of everything in some sense, because it says that within this framework, within this supervisory system, with the cooperation of national competent authorities, the AMLA should develop and maintain an up-to-date and harmonized AML CFT supervisory methodology detailing the risk-based approach to supervision of obliged entities in the Union. This methodology is shaping by means of the regulatory powers. So, thanks to guidelines, recommendations, opinions, and regulatory technical standards that are provided for by the same AMLA regulation. So the core of this system is the development of a shared common supervisory methodology that will be shaped by means of the regulatory technical standards and soft law. Let's keep in mind that the AMLA regulation has more than 40 mandates to develop those regulatory pieces of legislation, which is, you know, quite a complex system. We do have a regulation, but this regulation is just a frame that will be completed by all those pieces of legislation that are very necessary, you know, in order to indeed find what this common supervisory methodology is. I will come back to this in a moment, just to show just to show how important and revolutionary this is. Think about what we have in the EBA regulation. The EBA regulation, of course, is entrusting the EBA, you know, to enhance convergence of supervisory practices. And I would say that one of the major provisions in this respect is Article 29 about the common supervisory culture. But here we are taking a step forward. It's not only, you know, fostering the same supervisory culture, is really detailing what the supervisory methodology is, which again, given that is a scandal-driven regulation, it shows what the very problem was at, you know, at the back of this reform. We do need to have common approaches. We do need to have common styles of supervision. We do need to have the same approach. And this is, of course, very complicated. It is very complicated also in terms of what types of regulatory measures can be adopted by the AMLA. So if we take a look at Article 8, paragraph 2, what we can see is, first of all, that this methodology should be based on the risk-based principle, which is, as I would say, like an overarching principle that should be taken into account by the competent authority. And then it should contain certain specific elements, benchmarks and methodology for classification of the obliged entities, approaches to the supervisory review of the risk self-assessment, approaches to the supervisory review of internal policies and procedure, and approaches to supervisory evaluation of risk factors. Now, it shows how, you know, wide the action will be, but of course the tool that will be used by AMLA in shaping the supervisory methodology will be different depending on the nature and on the topic. And this could be found well described in the recital number 10, where the same regulation is saying, given that the AMLA is developing the supervisory methodology, there are aspects where there are quantitative benchmarks. For example, the risk profile of obliged entities. And for this aspect, we do create regulatory technical standards. So directly applicable rules, no discretion at all. But other elements where there's the need to maintain some discretion, we are going for the soft law, so guidelines, for example. And this area is the area of internal governance, policies, procedures, which is a very delicate one, and which is an area that, if you look at the regulation, where you find not the AMLA regulation, but the AML regulation, you can see that there's a big emphasis on the internal governance of obliged entities. So it's a big, big topic. And yet in this respect, and I would say rightly so, the approach and the policy is for the let's say soft law instrument, for the soft law tool, rather than the regulatory technical standards. And another aspect. Yes, sorry, and I'm about to finish, but I think it's an important innovation. Another aspect that is mentioned is the need to coordinate the AML supervisory methodology with the prudential one. So with prudential supervision. Of course, here I'm talking about the financial sector only, even though we all know that AMLA will be responsible not only for this sector, but in relation to the financial sector, what I see is the important integration between the different let's say, areas of financial legislation and financial approaches. And this push for synergies between the AML supervisory practices and supervisory methodology and prudential's methodology is really essential. I think it will be an important area where also the upcoming secondary legislation and also soft law can give us more indications on how to create those synergies between supervisors. This is also confirmed in a couple of articles, I think 40 or 41, concerning the cooperation between prudential supervisors and the supervisors that are and the AML supervisors, so the AMLA and the national ones.
Thank you very much, Andrea, also for elaborating in very much detail how the law would look like. I think it's also a praise to the Commission, Olena, to you, for putting this together in such a great form. I think that was also one of the outcomes of Andrea's presentation. So thanks very much. And we're coming now to the Q&A part. We don't have that much time left, but still a bit. There's also a chat function for the audience, which you see on the bottom right, where you can ask your questions directly. I've seen somebody already ask a question. Olena directly answered it in the chat. Usually I can also read it aloud if it fits to the current discussion point, but feel free to ask any question in the chat. I would start with a few questions on my side. And the first one, I think, is a follow-up to some points which have been already discussed in your presentations. I mean, I'm not an expert in anti-money laundering and everything related to that, but the people I speak to, they say AML and such a new authority would be a classic field for establishing basically a huge database of financial transactions, combining databases from national authorities and also artificial intelligence to analyze such databases. Is something like that envisaged? Because Olena, you also mentioned that there should be a closer cooperation and coordination of the FIU units. Yeah, does it also entail that the AMLA will establish a huge database of financial transactions within, let's say, the remit of this authority in order to better analyze the impact and potential AML or money laundering cases?
Okay, the very short answer is no, because all the suspicious activities and transaction reports are still going to first go directly to the National Financial Intelligence Unit. They will not go directly to AMLA. And that was very much on purpose, because all this data is analyzed very much in a context in each member state. There's a wealth of other types of data that is used to produce financial intelligence, to which only this national FIUs have access. And that starts with, but is not limited to, all the law enforcement data, the databases of the police, of the customs, of the judiciary, and so on and so forth. That is how it's analyzed. However, as I've mentioned, what we're aiming at is this joint analysis of cross-border suspicious in AMLA at EU level. How it's going to work in practice is that whenever the FIUs or AMLA determine that there's a potential case that should be analyzed should involve several member states and several FIUs and may lead to determination of criminal suspicion at EU level, this data can be pooled. So all the data related to that specific case can be pooled and analyzed jointly by the FIUs and AMLA staff. And AMLA will need to be equipped with appropriate IT infrastructure and IT tools for that. What we have provided in the legislation is the ability to have access to operational data, both for AMLA, but also for the FIU staff that is doing this joint analysis in AMLA, and ability to procure any tools and infrastructure which is required on a cost-benefit analysis, but obviously we are looking at being able to use the most advanced technology. And this is, I can tell you that this is now one of the biggest let's say, tasks and brainstorming points for the task force of AMLA, which is in the commission, which is supporting the establishment of the agency. What would be its IT infrastructure and data needs? So no single database of the suspicions reported. They are still being reported at national level to the national FIUs and put in the context of all the other data that the FIU has access to. However, on a case-by-case basis, and then pooling of this data and analysis of a case can happen in AMLA, yes.
So can I imagine it in this case that one FIU is identifying a suspicious case, reporting this to the AMLA, and the AMLA would be able to kind of look for similar cases with all the other FIUs in all the other jurisdictions?
It's a bit already simpler than that because the FIUs already have a common platform for information exchange, which is called FIUNet, which is going to be hosted by AMLA. But it's a platform exchange. It's extremely secure. There's extremely limited access. So there will be various ways to identify that several member states may be involved. Several FIUs may have relevant info. It can be identified by AMLA, can be identified by one FIU, by several. Either of those, either AMLA or one or several FIUs, may call for a need of joint analysis. So as opposed to just bouncing the data about individual transactions via FIUNet platform, they do the analysis together and pull all the data for it.
Thanks very much, Olena. Roger, Andrea, if you have any comments on that point, please.
Yeah, if I may, very briefly, yeah, it seems that some have an idea of integrating everything. Well, there are different tools, and each tool has its own objective. In this field, well, generally in the field of anti-money laundering, there is a distinction between the strategic work and the operational work, the tactical work. So I think AMLA is first of all entrusted with facilitating, coordinating work or at strategic level. So that's all the task related to what I would call prevention, risk assessments, and so on. And then there are indeed different work streams to help I would say, the joint operational work. And I have mentioned it in my introduction. AMLA can be involved in public-private partnerships, which may be operational partnerships, and exchange some tactical data with obliged entities and competent authorities, but there are conditions. So this is also very much governed by the AML regulation and Article 75. So you have to put in place safeguards in the exchange of information.
Thank you very much. Good, and I see actually one question or two questions in the chat. Maybe the last one I would start with: how would an appeal of a directly supervised entity to an AMLA decision look like, where such AMLA decision would lead to a national criminal prosecution of the financial entity? Would this be composite procedure, or would there be considered separate administrative criminal proceedings? Maybe Olena?
Yeah, so the short answer, the decisions of AMLA can be challenged by an entity either in a court of law, but that would be exclusively the Court of Justice of the European Union, so general court in the first place, or in administrative procedure, an administrative body within the AMLA itself, which only has advisory powers. It's called Administrative Board of Review. It's modeled upon the SSM. It can advise the executive board to review its decision. However, on the criminal bit, we are talking only measures that AMLA is imposing for administrative breaches, and those are administrative measures, whether pecuniary or non-pecuniary. Any criminal matter that may be discovered by AMLA in the course of its supervision or any other task has to be referred to national law enforcement authorities as appropriate, or union law enforcement authorities, because it might be the case that concerns, for example, the jurisdiction of EPPO or the jurisdiction of OLAF. So AMLA has an obligation to refer this matter. If it concerns any criminal suspicion whatsoever, the matter is referred to national law enforcement authorities. So there would be no sort of joint criminal/administrative case in the first place.
Thank you very much. There is also another question which was asked beforehand. You addressed this briefly, but there has been, or I think Andrea mentioned this, there has also been a AML mandate of the EBA. The SSM obviously has, to a very small degree, also some responsibilities if they detect suspicious cases. So the question we have here is, how is the interaction going to be between the ESAs, and I would actually also add the SSM and the AMLA. And here in this regard, I also would like to welcome Anneli Tuominen, and we have here from the SSM Supervisory Board, who is also in the audience. So that's probably going to be an interesting question as well. So how is the interaction between ESAs, SSM, and the AMLA?
Yeah, there is the regulation is stressing pretty much these cooperation between the different supervisory authorities. Concerning the ESAs, there's a specific obligation for the AMLA. So there's an article, I don't remember the number, but in the regulation there's a provision that is asking AMLA to cooperate with the ESAs, in particular when it comes to the regulatory powers. So in designing the draft regulatory technical standards, guidelines, and they should be involving the ESAs, which again, I think, it's a good step in the direction of having like a comprehensive interpretation of all the pieces of legislation, so if you involve all supervisors and you receive the input, it could be also a good way to have like a strong and comprehensive opinion when you regulate something. There's also reference, as I said before, to the prudential supervisor, and specifically to the SSM, so to the single supervisory mechanism, and to the European Central Bank in this respect. Another thing that it's important, and I would like to emphasize again in relation to the single supervisory system, is this mutual assistance provision that actually is showing how important the role of the AMLA will be in supporting the national competent authority that might not have all the resources always available in terms of staff, training, development of best practices. I think it's Article 9 of the regulation, which is resembling something similar in the EBI regulation, but it is bringing again to a level that is more sophisticated, and that it show how these AMLA could help national supervisors that not necessarily have all the tools to fight and to detect anti-money laundering practices.
Maybe, Olena, before I hand over to you for that part, there's also a question which fits quite well to what Andrea just said. So there's a question, could you describe the situation where AMLA would be able to step in when national supervisors, does not address AML failings sufficiently well? Yeah, so how would such a situation be regulated, or what would be done in such a situation? Olena?
Very shortly before you may wish to pass to Anneli, two types of situations actually. In the proposal we had one, but eventually co-legislators agreed on two. There may be a request from AMLA to check directly to the financial supervisor in case there are compliance failures at an obliged entity. and they are not adequately addressed. And the idea of the process is first AMLA checking whether the supervisor is on top of the situation, dealing with it appropriately, has the tools to deal with it appropriately, has already, I don't know, sanctioned the entity or required specific measures that would aid the situation or not. And AMLA can instruct what those measures should be. And only if the situation cannot be resolved in that way, so essentially the supervisor may say, look, I understand, I see the problem, I have imposed some sanction, it's not going to work, I don't have the resources to dedicate to this issue now, then AMLA may request to take over, but that request has to be, let's say, approved by the Commission due to Moroni Doctrine. But there is a separate situation, a distinct one, which is when a financial supervisor or a couple of financial supervisors may concern a group are actually of the opinion that AMLA should take over because the EU level supervision would be more adequate in dealing also with an acute underestimation of risk situation or compliance breach situation or complex cross-border situation where the supervisors, given their limited competence, are in a worse place to address an issue than AMLA is. So if that request is addressed from the supervisors to AMLA and the criteria that are listed in the provision are fulfilled, do exist, it is grave enough, it is in the interest of the union for AMLA to take over, then AMLA can take over without the intervention of the Commission. So it's, let's put it this way, the short answer is quite flexible. Both mechanisms are flexible. The first one is not so much focused on directly taking over. The first one is focused on being aware of the issues, understanding them, fixing it by instructing the supervisor to act in a certain way. The second one is really, it's better for this to be handled at EU level quickly.
Okay, actually we have now somebody, Anneli, who I welcomed before and who would like to say a few words. Anneli, I think we included you now and you should be able to say something.
First of all, thank you for the very good presentations. I mean, I really loved them because they were so much to the point, so concrete, so pragmatic. But thinking of the ECB and AMLA, of course, very good exchange of information and cooperation is needed. And for that purpose, also a memorandum of understanding will be drafted regarding the exchange of information. And regarding the ECB, what is especially where the information from AMLA is very useful, it's when we do our fit and proper assessment, when we grant authorizations, when we do assessment of qualified holdings, and of course when we look overall situation of the governance and risk management of banks. So we need to take also into account what's happening on this front. So overall, we think that this is a very excellent initiative, but of course it will take time because there will be so many supervised entities and so many stakeholders. It's a really tough, difficult exercise, but as long as we also remember to be risk-based, so I think that we get there. So thank you very much.
Thank you very much, Anneli Tuominen from the Supervisory Board of the ECB. We are now basically at the end of our time. If somebody wants to reply to that or make a last comment, then I would give you the chance, Olena, Andrea, and Roger. Otherwise, we can also close the event. But if you have any additional last comment on that, please feel free.
I guess I can only
Please, yeah.
and to be honest, the SSM experience was what we had been inspired by. I actually worked on that as well, personally, and it's very true. And I think it really has to be acknowledged that it's a long process. It will take a while to develop this common supervisory methodology, and Andrea's analysis was absolutely accurate, and the common supervisory culture. And it's also a different situation from the SSM in many respects. So we do have to be, let's say, very, very patient, but we have done what we could do on our part in terms of putting this legislative framework, which is rather clear and does have a lot of powers and does give a lot of possibilities. So now it is about taking the chances and also being quite patient and acknowledging that it's going to be a long road.
Thank you very much. Very good. Then I thank all of you. Olena, thanks very much for taking the time presenting us the AMLA. Roger, commenting this from a, let's say, EBF perspective, from a bank's perspective. Andrea, and thanks very much also for your elaborations from an academic perspective, who has been working on that a lot in the past. So, and also to the audience, thanks for participating in this event, and I hope you have a good rest of the day. Thanks very much. Bye-bye.